Hi, this is Jack Meligan, your Medicare problem solver for the Plaintiff's MSA and Lien solution. Today's video is entitled, Why Do an MSA? Is your client a gambler or are they a protector? So, if liability MSAs are not yet required by law, then why would a plaintiff voluntarily create an MSA account? Yes, it's true, liability MSAs are not yet required by law, but that misses the bigger point. That the law since 1980 has said that Medicare is secondary to all forms of insurance. Workers' comp, liability, no fault, and underinsured, uninsured, and self-insured all also qualify. Medicare is precluded from paying for services or injuries for conditions that are the subject of your client's settlement. Since 1980, high-ranking CMS coordinators and directors have issued various memoranda in support, and the one written by Region 6 CMS Regional Coordinator Sally Stalcup back in 2011 is especially instructive because Stalcup said, quote, Medicare's interests must be protected. However, CMS does not mandate a specific mechanism to protect those interests. The law does not require a set-aside in any situation. The law requires that the Medicare trust funds be protected from payment for future services. Whether it is a workers' compensation or liability case, there is no distinction in the law. And each attorney is going to have to decide, based on the specific facts of each of their cases, whether or not there is funding for future medicals, and if so, a need to protect the trust funds. And then this statement from Stalcup, quote, set aside is our method of choice and the agency feels it provides the best protection for the program and the Medicare beneficiary. So, if Medicare is precluded from paying, that means that Medicare is supposed to deny payment when they discover that your client has had a settlement. And Medicare is placing the responsibility on you, the plaintiff's attorney, for deciding whether or not there is funding for future medicals in a settlement and the need to protect the Medicare trust funds. Just how does Medicare discover your client has had a settlement? Because since 2012, defendants are required to report settlements with those plaintiffs that the defendants determine are Medicare eligible beneficiaries at the time of settlement. And if your client doesn't become eligible for Medicare until months or even years after settlement, they can still be susceptible to self-reporting when they receive the government's infamous red letter or a welcome to Medicare letter that includes questions like, are you receiving treatment for an injury or illness which another party could be held liable or is covered under automobile no-fault insurance? So, if Medicare refuses to pay, then who pays? That would be your client, the injured plaintiff. Your client will have to write the checks to cover the bills that Medicare won't pay. When that time comes, will they have enough or even any money at all to pay bills that Medicare is denying? Well, hard to tell. But that is precisely why a plaintiff would create a voluntary MSA today, even though not required by law, so that they have a designated account or pot of money from which to pay for Medicare allowable future services related to the treatments for injuries or the conditions that were the subject of their settlement. And so that they don't have to worry that they won't have the money in their checkbook and be left to beg for help. In other words, they are a protector, not a gambler. The best part is, if a plaintiff voluntarily creates an MSA, when that MSA is exhausted, Medicare by law must then cover them for everything, including settlement-related services for the rest of their life. The second best part is, with no rules, regulations, or guidelines on how much to place into a voluntary liability MSA, we at the Plaintiff's MSA and Lien Solution can take the same measures any reasonable person would. We minimize that MSA to the absolute lowest defensible dollar amount possible and effectively cap your client's exposure to Medicare at this minimized number, instead of risking that Medicare discovers your client has had a settlement but did nothing to protect the Medicare trust fund, and then Medicare taking the position that your client must prove that they have spent the equivalent of the entire settlement on Medicare allowable expenses before Medicare will cover them for anything that is settlement related. Help is just a call away. Protect your client. Limit your liability. This has been Jack Meligan, your Medicare problem solver for the Plaintiff's MSA and Lien Solution.